We're shooting now whenever you're ready.
Hi, students, we're back. Let's talk about Chapter 1, Knowledge of Law as a Business Asset. This is going to be a very brief chapter. This is our introduction to business law. We're going to try to have some fun. I might occasionally do things that are a little quirky. I may occasionally have background noise just because I'm trying to wake you up. But notwithstanding, we're going to talk about business law. All right? Make sure you're reading these chapters, because I'm obviously not going to be covering everything verbatim throughout the course of every chapter. It's impossible. If I go page by page, we would be here for far longer than anything we've previously anticipated. Let's move on to, let's start on page 3, guys. All right? You've seen an example on page 2. I strongly urge you to review the example with regard to Lionel and Chelsea's eggs and poultry. On page 3, we talk about law in the business environment. And we define what business law is. And you'll see it listed there. It's a set of established rules governing commercial relationships, including the enforcement of rights. All right? In order for us to have any sense of how we can go about, doing business here in Canada, we need to be able to have rules. Otherwise, without the rules, you have chaos. There is no real system. And we need to be able to make certain that businesses can enforce their rights, whether it's through an administrative mechanism, such as going to the various ministries or registries, or separately through, including last night until 11 o'clock for me, the courts, making certain that there are ground rules that all businesses need to follow, need to comply with, need to adhere to. If you go down further, we see in bullet points toward the bottom of page 3, business law defines the general rules of commerce, protects business ideas and more tangible forms of property, provides mechanisms that permit business people to select their desired degree of participation and exposure and risk in business ventures, seeks to ensure that losses are borne by those who are responsible for them, and facilitates planning by ensuring compliance with commitments. Effectively, these 5 bullet points just reinforce what I just told you before. It's all about the rules. It's all about protections, whether it be protections of ideas, which we see through intellectual property, patents, copyrights, trademarks. Say that some of you are fans of the hit Broadway musical Hamilton. All right? Hamilton's very popular. It's bringing a whole new group of people into Broadway music. Hamilton is a protected property. The images, the logo, are trademarks. The music is copywritten. Say that some of you have your own blogs and you want to post an image from Hamilton onto your blog. Can you do that? The answer is not without paying the owners of that mark, of that copyright, the amounts that they are otherwise due in order for you to then put it onto your blog. Protection of ideas. We also talk about protection of more tangible assets, meaning something that's not just ideas, but something that can be held. Whether it be a cell phone, whether it be a building that we're standing in right now, this studio, this is tangible property. Stuff that we can hold and feel and sense. Some of you may come from agricultural communities. Apples, obviously, tangible property. The relationships there are defined by a bunch of rules, a bunch of laws. And it's going to be your business to be able to actually understand what those laws are and how you can best follow them. Not only that, how you can best follow them, making sure that the person that you're doing business with, or the other company that you're doing business with, or companies that you're doing business with, are going to follow those same rules. You have to know the rules in order to be able to effectively practice in business. That's what business law is all about. You'll see on page 4 a good understanding. Facebook seeking justice against a notorious Canadian spammer. It's involving what are called phishing schemes. And again, Facebook is trying to prevent their network from being misused by somebody who has a purpose that is out of touch with the law, out of touch with Facebook's own aspirations for its technology. Please read that over carefully because it will give you a good sense, especially in a modern scheme, exactly what some of these rules might be. Now, we go to page 5 and we talk about rules and principles. It breaks down the protections under the law. Heck, it even defines what law is, which hopefully all of you know. It protects persons and property. The law protects persons and property, and they cite specifically to the Criminal Code of Canada. If you weren't already aware, in Canada, criminal law is based upon federal rules, federal laws. It is the federal government that gives us criminal laws that define what type of behavior is illegal. So these laws impact, obviously, business law. You think to yourself, how is criminal law business law? Of course it impacts it. It defines how you're going to be protected, how your person's going to be protected, how your property is going to be protected. But not only that, of course, if you overstep those rules under the criminal code over the course of your business, if you're involved in a securities business, for instance, or regardless of the business, if you in some way commit something that might raise an allegation of tax fraud. Again, it doesn't make a difference what your business is or whether you're even in business. If you're engaged in tax fraud, the criminal code impacts what you do. There are other rules that we'll see. If you're involved in something that involves mining or agriculture or some other business that could potentially impact the environment, you're going to see that there are rules and principles that are designed to protect society. If you don't pay your taxes as a business or as a person, you're negatively impacting our society. You're negatively impacting the ability of the Canadian government to assist other people in living and being able to do business practically. We see on page 7, and we're going to get into this a lot more in the coming chapters, we talk about something called breach of contract. You'll see it's defined there. It's the failure to comply with a contractual promise. A contract normally involves a mutual set of promises between two or more people or entities, two or more people or companies. That's what a contract is. It doesn't make a difference necessarily if it's oral, meaning the spoken word, or if it's written. Normally, I'm mentioning this in the summaries going into each chapter, it's highly, highly, highly desirable to have a written contract, even if you think that you're doing business with a close personal friend. It's nothing personal. You have to understand, though, however you may feel or however you might trust somebody right now, that relationship may change over the course of days, months, or years of doing business. You may have different perspectives. You may grow in different ways. We talk about contracts and we talk about what happens when there is a breach, a violation of the contract, when one or more of the parties disregard what the original promise was and how you go about enforcing it. Normally, those types of issues are settled in a courtroom. Again, we have a lot of great examples here in this chapter, and you'll see one with regard to Maple Lodge Farms conviction, and then you'll talk about later about regulating the tanning industry. These examples, which we're not going to go through through my video lecture materials, are key to your understanding, your greater understanding of these concepts. It helps to put them into real-world situations. So I strongly, strongly urge you to read those over to not just enhance your own comprehension, but to understand where we're going to go with the assignments and the exams in this course. We talk about next, on page 9, contract law and trying to facilitate interactions. Contract law is defined on the very bottom of page 9 as rules that make agreements binding and therefore facilitate planning and the enforcement of expectations. All right, we like to have contracts because we like to know what we're going to do, how we're going to plan things out, and we like to make certain that, God forbid, something happens. where one party doesn't follow through on their contractual obligations, that there is going to be some method to enforce. And this is important because contracts, oftentimes, even in what you might think are going to be the simplest, most general settings, do require some bit of complexity, do require you to consider what if. What if something happens down the road and there's some event that occurs that somehow impacts your contractual relationship? What is the enforcement mechanism? What can you assert? Are you going to have to go to court? Where do you go to court? How do you go to court? Are you allowed to go to court? Does the contract, just like you'll see in a Facebook contract, insist that you can't go through the court if you have an issue with Facebook, but you have to go through, as we'll discuss, an arbitrator? These are all defined. Those are just a couple of examples of what's defined within a contract. But it's important for anyone involved in a contract to understand what the expectations are for them, as well as for the party or parties that they're going to be making a contract with. On page 10, the most important thing that you could perhaps understand is this notion of litigation. Litigation, in short, is a lawsuit. Somebody files a lawsuit in court against another individual. We're not going to go at this point into what types of litigation there are and where you file a lawsuit, but litigation is the opposite in legal terms of transactional. You can write contracts, that's a transactional issue. Or if there are disputes, you can settle them in court. That is litigation. I am a litigator. I go to court often to deal with issues like this. Ultimately, if you go to court, who is deciding the issues? Who is making the ultimate judgment as far as who is liable, who is wrong, and who's been victimized? Well, normally that's a judge, especially on issues that involve interpreting a law. It is always a judge when it is an issue interpreting the law. Who decides the facts and who's right and who's wrong, and whether or not one side is more believable than the other. Oftentimes it's also a judge. And then on certain occasions there may be a jury. But oftentimes, especially in Canada, it's done by a judge. So the judge here will decide both the facts that can be believed and will also decide the law that surrounds those facts, especially, again, if it's interpreting a common law rule or if it's involving something that's in a written law. And we'll get into common law rules a bit later. Something that begins at the very end of page 10 and goes on to page 11 as well is our introduction to alternative dispute resolution. And the initials for that are ADR. Alternative dispute resolution. Critical in a legal system because, guys, could you imagine if every case went to trial? Could you imagine what would happen? And so over the years, as we've seen our population grow and as the number of cases going through the court system has continued to get higher and higher, public policymakers and judges have gotten together to try to figure out, is there a way of achieving a greater number of settlements to issues, especially in a business context? And they've come up over the past 20, 25 years with this notion of ADR, and they've pushed ADR mechanisms. And there are three primary ones that we'll be discussing in greater depth throughout this course: negotiation, mediation, and arbitration. You'll see two of those defined on page 11. Before we get to those, negotiation, just like you would do with a contract. When there's a breach of contract, the parties can negotiate out how to resolve, how to rectify, how to correct the breach. It's something that can happen between lawyers for both sides, or oftentimes it can happen just between the parties themselves. Normally, this is done in the context of litigation. And oftentimes, Actually, not oftentimes, sometimes. Sometimes the biggest impediment, the biggest barrier to actually settling a case can actually be the lawyers. We're so pepped up about trying to protect our clients' interests. And sometimes it is better for the two sides if they can talk to one another to do so without the lawyers being present. That's negotiation, talking out your issues. Mediation is defined on the right-hand bar of page 11, a process through which the parties to a dispute endeavor work to reach a resolution with the assistance of a neutral person. You get together, oftentimes in a conference room, and you have somebody who's been hired, who's being paid normally by both sides, to sit there and to be neutral, to be able to hear out the issues and to see if they can help the parties that are in this dispute find common ground, to achieve a settlement of the issues. In a lawsuit, oftentimes, a settlement doesn't give either side exactly what they want. It tries to come to some conclusion where one side gets something and loses something else, and the same for the other side. A mediator doesn't make any decisions. All a mediator is there to do is to listen and to persuade and to talk out issues to help one side understand where the other side might be coming from and to try to come to some greater, ultimate, binding understanding in a way to settle the lawsuit. The last part, the last type of key ADR is arbitration, a process through which a neutral party makes a decision that is normally binding and that resolves a dispute. An arbitrator is somebody who sits in a private capacity, just like a judge. You sit very much just like in a room that's formal. The arbitrator will sit just like a judge. Oftentimes the arbitrator is subject to the same rules of providing evidence that you would see in a courtroom. But this is not a judge who is appointed by either the province or by the federal government. This is somebody privately designated, selected by the parties to sit in judgment over this particular case. Again, it's a way of steering cases out of the court system and resolving them in a private fashion. And it's been effective over the past 25 years, extremely effective. Skip on to page 13, and we have to touch on, just briefly, law and business ethics. In order for business to function properly, not only are you going to have to know and understand what the law requires of you, you're also going to have to maintain a level of business ethics. It helps society function better, it helps business function better. And I believe from doing this for the 21 years that I've been practicing law, that in the end you actually make more money, rather than being the disreputable, lying, cheating styled businessman that you've probably seen at the very least depicted on TV and in the movies, or God forbid that you were the victim of in real life. So they ask these questions. These are the vantage points that are noted toward the bottom of page 13. Business to a consumer. How far should a company go in extolling, in bringing out the virtues of its product? When does sales talk become deception? This is huge. It's going to be huge. All right, that imagine any product. All right, let me talk to you. Let me talk to you about this watch. It's a good watch. Look at this watch. All right. Do you know what this watch can do? This watch is a beautiful watch. All right. It runs. It ticks. It does everything that you want to do. It even, if you're very quiet, it even talks to you. That's right. You're going to be able to do everything that you want with this watch. In fact, you know what? This watch, it's worn by famous people. I swear, you know, George Clooney will use this watch. At what point does the sales pitch go over the top? Has George Clooney ever worn a watch like this? And I don't know. I don't believe so. I think he endorses a different watch. But at some point, if you're trying to sell something to somebody, you could say this is a good watch. That's an opinion. It may very well be a good watch unless you know that it's the subject of various defects. You could say it ticks. The watch ticks. Does it talk to you? This watch does not talk to you. And no, George Clooney did not endorse this watch in any way. So at what point then, what's the dividing line between what is fair in making a sales pitch and what oversteps and becomes deceptive? Because if it becomes deceptive, not only could you be sued, you could also, depending upon the degree of deception, you could also be criminally prosecuted. The next bullet point, business to society. To what lengths should a company go to enhance a shareholder's returns? To reduce costs, should a business employ child labor in those countries where it's legal to do so? What if the child's income is essential to the family's survival? These are things that we have to deal with all the time. How many people here have Nikes or Reeboks or Adidas shoes? We all know with Nike that Nike does business in Malaysia and Southeast Asia. And we all know that, at least in the past, if not the present, that Nikes also are made through the use of child labor, which may be perfectly acceptable in those types of societies. So guys, getting back to our example, when is it worth it? What's our duty to society? We see instances where people won't shop for goods that are made in certain countries because of opinions with regard to how those governments conduct themselves, how businesses conduct themselves, who are victimized outside of Western standards, contrary to the laws that we have in places like the European Union, Canada, and the United States. At what point do business ethics stop and take a back seat to the ability to be able to get your product out there and make it financially viable for sale? A lot of people do business with Southeast Asia because labor is so cheap. But what are those people facing? And the counter to that is, listen, but for these businesses coming here, these families might not have anything. That what little they get helps their entire family survive. What's the counterweight there? Business to employee. Should a business monitor employee emails and internet use on company computers? Some of you may have specific opinions about that. Should a company be able to do that? Normally, you would expect that the answer is yes, especially if it's a company's computer to be able to monitor. Do we want Big Brother watching over our shoulder about everything? No, we don't. But at the same time, is there an expectation that whatever you're doing on a company's computer or email server could be the subject of review by your employer? Does it violate business ethics to do that? Business to business. Short of lying or fraud, is it ethical to bluff during business negotiations? And when does bluffing become a form of corruption? Guys, it's the art of the deal. And I hate to use that phrase, but it's the art of the deal. Exactly at what point, depending upon the nature of your negotiations, in order to do business with another company, are you going to be able to bluff? What does that bluff entail? Again, whether or not you cross over a threshold, over into from one point to the other, from doing business to being unethical, you're going to have to define necessarily what that is. I think we all generally know from our own basic system of morals and ethics what should be overstepping. Because if you overstep, it's not just something that may be immoral or unethical, it may prove to be illegal. So that's our wrap up here, okay? What you should be looking at. We started this chapter with Lionel, all right? Those first couple of pages introduced you to Lionel. I'm going to ask you to refresh back to Lionel and then look on pages 14 and 15 and the top of page 16 to determine how business law impacts Lionel. This is going to be critical to you and for purposes of your completion of the chapter study. And you'll see from the assignment that I give you why you actually need to consider Lionel in a different context. The most critical part of your assignment that you're going to receive deals with questions for critical thinking, questions that require deep thought. And these aren't things that you're going to be able to simply copy and paste off some online page. Heavens forbid. This is designed to make you think deeper and better so that you can be more successful in business and in life. That completes chapter 1. Thank you.